Kolender versus Lawson. That is the name of a United States Supreme Court case that was decided back in 1983. I'm the Lawson part of the title of that court case, Kolender versus Lawson. Kolender is the then chief of police for the city of San Diego, who was the other party in that particular lawsuit. And of course, San Diego is a fairly affluent community. The case started very innocently. First day that I flew into San Diego, I meet some people just by chance. They invite me to a party. I go to the party. Party finishes, and it's a beautiful San Diego evening, so I decide I'll walk home. Start walking home, get halfway there. It's late at night. It's quiet. The crickets are probably chirping. All of a sudden, boom, a sheriff's car falls out of a tree. Sheriff comes out, and of course he's got, guns sticking out of him. He's got antennas sticking out of him, all that sort of thing. And he wants to know, do I have any identification? And of course, I being the curious type, I asked him, well, identification, why do I need identification? And he goes, you can do it the hard way, you can do it the easy way. Conversation escalates. Next thing I know, I am sitting in the county jail. I'm sitting in the county jail charged with a violation of 647E, which was the California ID law. And as I get further and further in this whole thing, what I discovered is that anytime that I was anywhere in San Diego where you had black people who were sitting around talking, or brown people were sitting around talking, or young people were talking, the conversation would take 3 minutes before it got around to everybody had a police ID story. Everybody had a police ID story, which seems to be like every other day of their life, they're being stopped for ID. And so I'm listening to all of this, and I'm saying, well, this just happened to me, and it's been happening to all you people. Why doesn't somebody do something about it? And that's, of course, when, everybody starts looking down at their feet, and everybody starts going with the hemming and the hawing, and all the reasons that this sort of thing had been tolerated. I said to myself and to anyone else that would listen, it strikes me that this kind of conduct, in addition to being a tad inconvenient, is also unconstitutional. And so I took the case to court and did everything I could win the case. I lost. Okay, so fine. You win some, you lose some. No sooner than I got out of jail for the first infraction of 647, the California ID law, then boom, another cop. Same question for ID, same interchange. And this one I didn't end up getting arrested for, but they held me for a certain number of minutes, hours, whatever. And this just kept on happening to me over and over and over again. Okay, so finally, about 15 times in 18 months, in all sorts of different configurations, I would be sitting in a restaurant. I would be, again, the inveterate pedestrian, which means I would be walking to one place or another. Sometimes I would be doing things as simple as I would be living in La Jolla, and I would be going from the front door to the curb or something that's and boom, they would hit me. So I took about 18 months to get 15 different occasions where they had stopped me for ID checks, 15 occasions where I had taken notes and got the policeman's badge number, written down a simple description of what was taking place, and I decided to take them all to court. Take them all to court to challenge as to whether this kind of conduct was constitutional. What I started out with was the assumption that I could basically get some kind of legal assistance, because like anything that you do in this country that involves law involves money. And so if you don't have a whole bunch of money, which I did not at the time, what you're obliged to do is to come up with some kind of legal assistance. So I started off by getting a list of all the biggest law firms in La Jolla, in Del Mar, in San Diego, all the places where people have lots and lots of money and should have, an interest in investing in or contributing something like this. And I went through this series of meetings where I'm going to see all these big-time lawyers and all these big-time offices with big-time secretaries and big-time mahogany desks. And, of course, all of them said some variation of no way. So the second thing I figured was, well, there's got to be all sorts of local organizations that should be like indignant and outraged at this violation of constitutional protocol. And so I went around to all the local, who do-gooders who are supposed to do this sort of thing and told them, why can't we attack this thing or do something? And of course, they all said no. So I was then left with basically the civil rights organizations, things like the ACLU, National Lawyers Guild. And the interesting thing is that at the very beginning, they said, well, we tend to do things that are real big, and this is real small. So that was a variation of no. So I had no other recourse but to walk over to the law library, open the first law book, and start studying the law so I could, in fact, do this myself, so I could represent myself, so I could proceed as a pro se or pro per litigant. And what essentially took place is over a period of approximately 8 years, representing myself, I first went to the state court, challenging the constitutionality of the ID law, and I lost. I then went to what would be the district state court of appeal, challenging the California ID law. I lost. I then went from the state system to the federal system. In other words, there's two different systems. There's state courts here. There are federal courts. Federal courts are big time. State courts are more or less small time. Went into federal court, district court, presented my case. I lost. Okay, then I went to the Circuit Court of Appeals. In this case, because it's California, it's something called the Ninth Circuit Court of Appeals. And the Ninth Circuit Court of Appeals was really the first court that took an intelligent look at the whole proposal. And I won. And that was, I'd been doing this now for 6 or 7 years, and that was the first time that I won. This is not an insignificant victory, because this particular law, this ID law, it was important for a number of reasons. For example, if you understand the Union of South Africa in the days where apartheid existed, you understand that one of the principal tools in segregating that community and oppressing the minority in that community was something called a pass law, which means that all the black people in South Africa had to have ID. They had to literally have an internal pass. And anytime they were anywhere, they had to be able to explain to the police authority what they were doing there, why they were doing whatever they were doing, and show them some kind of ID. We had in the United States, and in particularly in Southern California, the same kind of system. It was informal, that is to say, it wasn't written in law, but it was a practice. It was a sort of local Southern tradition. And this had been going on, and it had been like a black cloud over the day-to-day enjoyment of life, liberty, and the pursuit of happiness for anyone you talk to who was black, who was brown, or who was young. And of course, Southern California, that's a lot of people. This particular victory in the Ninth Circuit therefore had enormous ramifications to an enormous part of the population, the black, the brown, the young of that particular community. And because it's the Ninth Circuit, it was not only Southern California, not only San Diego, not only La Jolla, not only Del Mar, not only Imperial Beach, but it was the 9 states that make up the Ninth Circuit, which means California, Oregon, Washington, Nevada, Alaska, Hawaii, and maybe 1 or 2 more. It was the first time that the courts had really done something like this, in anyone's recollection. All through our campaign, been very interested in doing 2 things at the same time. One is changing the law, and 2, educating the public to the fact that this kind of work was being done, educating the public to the notion that as a private citizen, as a single individual, if you see something that is wrong, if you see government doing something wrong, if you see wherever it is you work doing something wrong, you can start yourself to try to change it. And this is a very important concept because increasingly we see in society, everybody looks around, everybody sees all kinds of things that are bad, and they figure it's somebody else's job to change it, not mine. People they'll listen to the news on the radio or the television and say, why doesn't somebody do something about it? One of the most significant things for me was to get it into the mind of the public through media that whenever you ask the question, why doesn't somebody do something about this? the answer to that question is looking back at you in the mirror, to get people to believe in their own abilities to change and control their own lives. And so we had spent a lot of time and a lot of energy doing everything we could to get press on this. And of course, the media campaign had gone just about the same way that the law campaign. We just couldn't get anybody to do any kind of media at the beginning. We couldn't get any kind of legal assistance at the beginning. And once we got to the Ninth Circuit Court of Appeals, it was the first legal victory, and then it just blew up the media thing, where nobody was writing anything on this before all of a sudden everybody was writing, anything they could get their hands on. And that was a major, major change point in this campaign. What followed from there is, because we had won in the Ninth Circuit, the cops then appealed it. And they appealed it the only place that you can appeal it to, which is the United States Supreme Court. And nobody expected this thing to go to the Supreme Court. And so we pretty much figured it was, over with. But to everybody's amazement, it was accepted by the United States Supreme Court. And this put into motion a major convergence of just about everybody who was anybody in the progressive, liberal, or civil rights community. One of the things that was very dramatic about this case was that it probably got more publicity, and it probably had more people participating as amicus curiae than perhaps any other case that was heard by the court that year. And that is a direct quote from whoever the Supreme Court reporter was for, I believe, CBS News. It was a curious undertaking, because the way that things work in the United States Supreme Court is it's in Washington, D.C. That's the only place it is. Everything that happens, you have to go to them. What they do is they have a period where you send them all kinds of briefs, all kinds of paper arguments. And then after they get the briefs, they have a period where they do oral arguments, where, presumably you go there and you just basically say, this is what I think is true, and they listen to you, and then they ask you questions, and then months later, they give you a decision. The most dramatic day in the Supreme Court is oral arguments. We'd done a bunch of work the weeks before oral arguments to get all of the press that we could interested, because, again, at every intersection in this project, my interest was in the education of the public, in changing the public's mind, in infusing these kind of ideas into the public discourse and therefore public policy. I was always as interested in that as much as in changing the law. And so, we're working feverishly to get all the press interest we could get, to get all of the media interest we could get, and to do little maintenance things like we had to actually physically figure out how to get to Washington, D.C. in oral arguments. We, of course, spent every dime we had on all of the press and all of the press packages and so forth. And it's a very good example of how if you start a great campaign, then stuff just happens when you need it. Miraculously, we're sitting there trying to figure out how to get to Washington, D.C. We get a phone call. It's ABC News. And the show is, I think, Good Morning America. And they wanted to know if we would be willing to do an interview with them on this, which is like a big deal. And we said, okay, fine. So automatically, plane ticket to Washington, D.C. So that was solved. The day of the oral arguments come, and I go downstairs in the elevator of the Mayfair Hotel. I needed a cab, so they got me a cab. I don't know what he thought I was doing, but he decided, since I told him I was going to the Supreme Court, that I obviously was part of the janitorial staff. And so the man delivers me to the Supreme Court, but to the servants' entrance. Now, this is, of course, a little piece of American history. I did not know that there was a servants' entrance in the Supreme Court. I should have figured that out, because people certainly are not going to clean up behind themselves. So, I should have figured that out, but I didn't know that prior to this. And so I get out of the cab. I started walking around the Supreme Court building, and you've seen pictures of the Supreme Court building. The front of it is this massive set of stairs that probably go up 2 or 3 stories, just stairs that just go up into the heavens, hopefully up to justice, although that's not always the case. And so I walk around in the front of the building, and I see the staircase, and about halfway up the staircase on the other side, I see this huge mass of sort of like reporters have basically glommed into this great reporting mass with microphone booms sticking out and people with pads and cameras everywhere. And I said to myself, well, I wonder if, who's being interviewed in the middle of all of this media stuff. And as I'm asking, I barely got the words out of my mind's mouth. Interesting concept. And I hear somebody in the crowd scream, "There he is!" And it turns out that all of the work that we had done, sending out all the press releases to develop all that media interest, there it all was. And they just, like a white sale at Macy's, they started stampeding, running towards me. Everyone that you could think of, NBC, CBS, NBC, everybody there. And they're covering the case. And it was a major, major story. It affected a lot of people. We did oral arguments. And then, I think about maybe 4 months later, I'm in Berkeley, California, a stone's throw from UC Berkeley, which is where I'd done a lot of the law research, a place called Bolt Hall, which is the law school on the campus of the University of Berkeley, University of California at Berkeley. Phone rings, and it was CBS News. And they it woke me up, of course. And they asked me if I wanted to make a statement about the report this morning. And they were the first to inform me that the United States Supreme Court had just announced their decision in Kolender versus Lawson, that we had won, that the courts had declared the practice of arbitrarily stopping Americans for no purpose than requesting identification when one is a pedestrian, when one is at liberty, when one is in public, it had been overturned. It had been ruled unconstitutional. And as such, that particular era in the long history of racial inequity had been brought to an end.